Due process. It's just my job.
It's just my job? Right. So criminal law is one of those areas that is, first of all, it's on television all the time, right? So you've got that sort of media coverage, whatever, and it's the most gruesome, right? Because you're dealing with like the worst kinds of human conduct, right? That then the state or the government or the country that you live in says, you know what, like, we don't like that. So you're going to have the worst kind of possible penalty. So today is criminal law and a little bit about corporate law, which, you know, maybe it'll be more suited to some of you. Okay, so today is good stuff, criminal law, and I'll tell you that, just FYI. So your textbook, my textbook is coming soon. So your textbook, the authors of the textbook, in their wisdom, from the last iteration, which was a few years ago, to the one that you currently have, beefed up the content with criminal law, because we'll look at a bunch of cases that were decided to kind of offer clarity and direction and so forth. So the authors of the textbook, in their latest edition, in their wisdom, decided we should think about this stuff because it has all these ethical issues involved. And even if you don't necessarily practice in it, it's a fertile ground for ethical issues. So that's today's topic. Okay, so first, who's this? Miranda Hobbs. Who's Miranda Hobbs? Sex and the City. So who's watched that show? It's long gone, right? It's over. What kind of lawyer is she? Does your wife watch it?
No.
It's an old show. What kind of lawyer is she? Like, you know, in terms of our context and ethical considerations. What kind of lawyer? She's a corporate lawyer, right? She works in the corporate world or whatever, what have you. And her character is a character that is, you know, perfectly ethical and works within the boundaries of her ethical responsibilities. It's fictional, it's an American show, whatever. But she faces issues such as glass ceiling, right? Glass ceiling. And she also faces issues of the, it's called, there's a name for it, it's called the mother effect or the mother detriment or something. And so what happens with her is she has a baby, and then her career, she's out of the workplace for a period of time. And that is, as a broader social issue, for women who are lawyers who take, you know, time out because you have a baby, sometimes getting back on the career path is a challenge. So those are some of the issues involved here. Hi, good morning. We're okay. Thank you. Okay, so that's our fictional lawyer for today. And did anybody bring me a joke? I don't even know which jokes I've told anymore, so I've got some ones to read, some rapid fire. Rapid fire. Reader. You can read? Rapid fire jokes? Just read like 2 or 3 or 4 of these. You're just a random Q&A, nice and loud.
You're on.
Sorry. See how they're all Q&As?
Yeah.
Just do a Q&A.
Q&A question. What's the difference between an accountant and a lawyer? Answer. Accountants? No, they're boring. What's the one thing that never works when it's fixed? A jury. Why did God invent lawyers? So the real estate agents would have someone to look down on. What's the difference between a vacuum cleaner and a lawyer on a motorcycle? The vacuum cleaner has the dirt bag on the inside.
Okay, so think about it before you buy a motorcycle. Thank you. Okay, so let's go to our criminal content. All good stuff. Where is it? Okay, so criminal. I just told him everything was okay. there's my disclaimer. And so today we're talking about two specific areas of practice. So our ethical obligations belong everywhere, no matter where you work and what you do and so forth. But then we zero in on a couple of areas, and there's one, the next class as well, which is government lawyers, where it's a little bit more unique. And we just talked about criminal law and how sort of difficult and fraught with ethical issues it can be. Okay, so criminal law. So one of the most powerful aspects of Canadian criminal law is the presumption of innocence until or unless proven guilty. Why is that, like as a first principle, why is that so powerful? Why is that such a cornerstone of the Canadian system? And many other systems as well, but not everywhere. Why? Why is that considered seminal in Canadian criminal law? What's the alternative? And I think, I don't know, maybe someone has some experience, but I think in some countries, you might have an alternative. So what's the alternative to not having a presumption of innocence? Madison.
Presumption of guilt.
Right? And then what? And then what? Then it's up to the defendant, the accused, to prove. So imagine the reverse. Now again, I couldn't name a geographic region or anything, but I think in some cases that's the problem. So what we have in our system is the, in quotes, advantage to the accused person that they're presumed innocent the minute they walk into the courtroom, the minute they walk into any process in the criminal law justice system. The presumption is you're innocent. Now it's the job of the Crown Attorney to prove otherwise. So all onus on the Crown Attorney. Prosecutors have a duty to ensure the truth is exposed in court. And prosecutors, and we'll see a little bit more of this, prosecutors, their job isn't to find a way to prove a person guilty. That's their job, assuming the evidence is in place. But the main goal and thrust is fairness. The duty to ensure the truth is exposed, fair process. So while you have the Crown Attorney representing the Crown, right, the country, the criminal code of Canada, the accused is entitled to have what we said earlier today. They're entitled to have due process. They're entitled to have someone to represent their rights and have a fair hearing, and defense counsel. So you have two bars, right? Two professional legal bars. You have Crown attorneys and you have defense counsel. So defense counsel, that's their own group, they're committed to do everything they can to ensure that the client is acquitted and the state does not exercise its considerable powers of punishment without respecting the rights of the accused. Okay, so before we get to our main question, why, and again, these are fundamental issues. Why is it the Crown's duty to prove guilt and a presumption of innocence? Why do we have that? Why is that balance, defense versus Crown? Why is that? Okay, there's the Crown Attorney, right? And there's the defendant. What does the Crown Attorney have at their disposal? What does the Crown Attorney have at his or her desk when they stand up in court and they have a criminal trial proceeding? What do they have? What's behind the Crown Attorney before you get charged? So they have police, right? They have police. What else have they got? What if there's blood involved? Blood. Yes. So they have experts, right? They have DNA, DNA testing. They've got labs, right, to work on the evidence. They've got staff. They've got like an office full of people that can help them, right? And they've got resources from the government, right? They're not waiting to be paid by their client. They're paid. They're salaried employees. They're government employees, right? They don't have to worry about whether they're billing and so on. They've got the government behind them. And they've got powers, right? They've got powers. They can subpoena people. They can order tests. They can, and all of this is paid for. In other words, there's no extra money to the client, right? And what does the defendant have? What does the defendant have in comparison to all these powers, resources, personnel, and staff? What does the defendant have?
The lawyer.
Pardon?
The lawyer?
One little lawyer, right? Little tabs, a robe, and a briefcase. And that's what the defendant has. Now, mind you, fair enough, if you're a filthy, stinking rich defendant, right? Or accused, I guess is the proper word. You know, you might have some money and you might hire your own experts and so forth. But you know what? By and large, the population of the accused, what do you think? Rich or poor? Yeah. So here's what they've got. They've got this little guy down here who may be paid by, depends, right? Could be legal aid, could be personally funded and so forth. So we have this fundamental imbalance of power and resources. So what the system over the decades, and I guess even hundreds of years, has developed is this notion of, you know what? You've got all these advantages. We're putting the entire onus on you. Crap. This guy, no. He's innocent. He's innocent. Tell me otherwise. Prove it otherwise. So you've got that imbalance, and that's the background to it. You know, or something. So, going back to our earlier question, how can you defend someone you know is guilty? And we've talked about some of the ideas and notions behind that. And it's a broad moral question. It's a broad moral question, and ethically, a lot of factors come into play for sure, whether you're on Crown or defense. Okay, so do I have the textbook? Okay, so can we please turn to well, let's reference page 66. I'll have to borrow someone's book just quickly. You can share? Thank you. Yours is not highlighted, so I know where to read. Or maybe it is. Page 66. Number 7. No, please excuse me. Page 419. Page 419, and okay. So the reason I flagged 419 is because who's heard of Jian Gomeshi? Okay, and what's Jian Gomeshi's deal? What's his deal? So top of page 419, let's have a reader for that little section. Reader? Simon.
The high-profile trial of Jian Gomeshi, R. and Gomeshi 2016, and the public discussion that surrounded that case engaged many of the difficult evidentiary issues and challenged public perceptions that are raised by cross-examination in criminal trials, particularly involving sexual assault allegations. For a recent discussion of these issues, see Alice Ruby.
Right, so Alice is one of our authors, right? So she writes extensively on that. And what happened in the Jian Gomeshi, does anybody remember? Like, it's not in your textbook, except for that little reference, but the case is not. Does anybody remember what happened to Jian Gomeshi in that criminal trial? So a number of women accused him of sexual assault, violence, and so forth, and the case is highly defended because, well, actually he had some money, so he could hire an expensive lawyer and things. That was an interesting case in terms of disclosure. Maybe we'll touch on that if we have time. And what happened was, on cross-examination, many of the witnesses' evidence fell through, and the criticism was the balance between the Crown attorney presenting the case, right? Because that's where the onus is. So he was acquitted, right? So the Crown attorney presenting their case, including witnesses and subpoenas, I might write everything down, versus the notion of how sexual assault criminal cases unfold and historically, problematic issues with victims and so forth. But so that's just an example, a real-world example of one of the ethical issues and problems that criminal law generates. Okay. So this morning we said, how can you defend someone who's guilty? So there are a number of reasons and notions that many of you have raised in terms of how you respond to that at the cocktail party. But there are also some theoretical sections. So I need a reader for page 484 to talk about some of the, and these are more theoretical aspects. Some of the reasons why criminal defense work is, people go into criminal defense work, philosophically speaking. Okay, 484. 484. So there are 1, 2, 3, 4, 5 sort of theories. We'll just touch on them. Do you want to read them? Review them? Okay, so garbage collector's reason, someone's got to do it, it's a dirty job. Legalistic or positive reason, truth cannot be known, facts are to be determined by the adjudicator. Political activist reason, social workers reason, those accused of crime are the most disadvantaged. We know statistically they tend to be in the poor financial sort of strata. And egoist reasons, defense counsel find it interesting and fun. And you know what? If you do criminal law, if you like to be a litigator, you will be on your feet. You will be doing evidence, witnesses, cross-examinations, last-minute surprises. So all very on your feet, active, and for some people really interesting work. Okay. Am I going right now? So why do they become? Criminals are sometimes victims, prison conditions, accused persons, because we have this high hurdle, this onus. Why? Why? Because what's the ultimate outcome? What's the worst possible scenario if the Crown is successful?
Incarceration.
There goes your freedom. You can't see your family. You can't go to work. You lose your job. Like, it's the most serious, right? It's the most serious outcome. We don't have the death penalty in Canada, but it's the most serious outcome is prison, right? So that's part of the imbalance there. So if the Crown stands up and says, here's my police report, and here's my expert's report, and I've called these witnesses, and I've got the DNA, and I've got the lab tests, and I've subpoenaed all my witnesses, and here's the victim and so forth, and here's my case, what can the defense do for the accused? Can they do nothing? Or do they have to do something? Hands up. The defense has to do their best and take some action against all of this. Hands up. The defense should do something. Okay. Hands up. The defense says, you've got the onus, you've got the burden, you've got to prove everything. Crown attorney, Madam Crown. I don't think you have. I'm going to sit down and say, I'm going to stand up and say to the judge, my lord, my friend has not proven this case. I'm going to sit down and do nothing. Hands up. Who says the defense can't do that? Absolutely. You can absolutely sit down and do nothing. You don't have to cross-examine. You don't have to have your own experts. You don't have to challenge anything. If, in your wisdom, your defense counsel down here, if you think this hasn't been proven, too bad for you, Crown. That's your job. You haven't done your job? I don't have to do anything. But you might say, well, we do have a problem with that one witness, and rats, we do have that DNA test, I better do something. So that's a judgment call you have to make. But in theory, if the onus has not been discharged, the defense can do nothing. Sit down and say, case has not been proven, I'm doing nothing. One of the other sort of philosophical backdrops to it is, remember, we have the police, right? The police that collect the evidence, do the interviews, and build the case, and then the Crown attorney takes it to the hearing. The police have to be held accountable to defend the integrity of the police, the due process, the police actions, and how many have heard about the, the news stories about police, the boy in the streetcar, right, with the knife and the shootings and various things, so that police actions have to be held to a high standard, and they stand behind the crown jewel. Okay. So you have a client. Do you ask your client, your defense counsel, do you ask your client, so I want to defend you in the best possible way, did you do it or did you not do it? Who says you should ask? Because you want to know what's going on. Who says, no way, man, I don't want to know this? So it's a kind of a debate. If you want to know the answer, then you must live with it. Like if your client inadvertently blurts it out or comes in crying or whatever, and you know you have no choice. But if you have a choice not to know, and you choose to know, then you're in a position where you have knowledge and you cannot act in good faith and ethically in front of your judge and jury, maybe, to put forth defenses that you know are not correct. So choosing to know the answer from your client gives you limitations and burdens. If you don't ask, then it's a fine line, right? Then you have the opportunity to put forth defenses so long as you believe they are properly held. And absence knowledge from your client, you can put those defenses forth. It's tricky. So the lawyer said, for example, if the facts are as you have stated them, then you have no legal defense. And you'll be electrocuted. This is in America. On the other hand, if you act in blind rage, there's a possibility of saving your life. Think it over. We'll talk about it tomorrow. Problem with that advice? Problem with that advice? Does that advice, and this is just an example, right? Does that advice skew what the accused might tell you? Okay. Be a little suggestive. So this is an example where the lawyer speaks to the accused, and this is an example where probably you crossed over the gray line, the dividing line into the gray area. Okay. So we know the Crown has the onus, right? They have to go first to prove the case. We know the Crown has the burden of proof, right? They have to overcome the presumption of innocence, right? They have to overcome with their evidence and all of the support they have behind them. But the Crown, so the police lay the charge, but the Crown has the sole decision as to whether to proceed with the hearing, accept a plea bargain, and their trial tactics. The duty is to remain neutral because the public is the Crown's client, right? Think about it. The Crown attorney acts on behalf of the Crown in Canada, formerly the Queen, whatever, the government, which is all of us, because we voted in this government. Thank goodness that's over. And the Crown's client is all of us. Winning is not the goal, fairness and full exploration of the evidence. So murder. Did I just do this one? Man. All right. So the Crown has obligations, right? And the obligations are seek a conviction flat. I mean, you wouldn't bring the charge if you didn't think you had enough evidence. Some people say there might be political pressure. You better bring this charge kind of thing, because it is the government. But generally speaking, let's just talk about generalities. The Crown will only bring forth a case with a reasonable expectation of success. Otherwise, what are we doing, right? We're just wasting resources and time and the court time and so on. So the Crown, once they decide, yep, I've got enough evidence here, they can seek a conviction, must seek to have a fair trial. The object is not to win, but to find the truth and uphold the accused's rights. Everything must be done fairly, and that's the driving role. So, okay, so page 511. 511. I'm going to read her now. 511. scenario 10. Sorry, role, see, it's not highlighted. I need to know which part to need to read. The role of the prosecutor. Okay, can someone read that section? Section C, that first paragraph under C. What's the role of the prosecutor? Can we have a reader? Nice and loud for everyone to enjoy on a Tuesday morning. So it's just that first paragraph. Thank you. Okay.
The prosecutor occupies a unique role in our criminal justice system. First, they do not have a client in the traditional sense of an aggrieved party or defendant. Their client is the Crown. Second, through the exercise of discretion, the prosecutor serves in many respects as a gatekeeper. She decides whether charges should be laid or withdrawn, whether to consent to bail, whether to agree to a guilty plea, whether to agree to a joint submission on sentencing, or whether to appeal an acquittal or sentence. Prosecutors are also advocates who must provide advance notice of their case through disclosure, present sufficient evidence to move the case forward and test any evidence held by the defense.
Thank you very much. You get the book back, I promise. So, one of the key aspects and obligations of the Crown, right, is disclosure. What's disclosure? It's kind of in the name, right?
Crown discloses the evidence.
Right, because who has the evidence? Like, right? They've done all this stuff. What has this guy got? Me. Emmanuel?
Got me, the lawyer.
He's got you. Doing the good work, fighting the good fight over here. Presumption of innocence, we believe in it, right? He's got nothing, or she. Or maybe, they have an alibi. I couldn't have killed the person. I was in Las Vegas playing the slot machine. Maybe, so we'll get to that in a minute. But generally speaking, the Crown's got all this stuff. So there's so many fundamental aspects to criminal law that are so interesting. One of the other fundamental aspects is full disclosure, obligation. This is your duty, Crown. And by the way, if you don't make full disclosure, consequences, you know how when your kids misbehave, it's consequences. So the seminal case, the key case that outlines the notion and the importance of disclosures, R.V. Stinchcomb. So R.V. Stinchcomb, right? Criminal case, 1991, and the Stinchcomb principle, it's now come to be known the Stinchcomb principle. The principle is the Crown must make, the background is Calgary lawyer, charged with criminal breach of trust. The defense said, no, we were partners. Defense decides to put in some defense. Crown had received some evidence in favor of the defense. The Crown, in all this giant package of stuff, in there somewhere, buried, is something that helps the defense. It's favorable to them. The defense doesn't know you have that. How would they know? They've only got a little defense lawyer, right? So, the Crown has to disclose everything. The Crown received favorable evidence at preliminary hearing from someone else, but didn't call that person at trial, the person who made the statements, and refused to give the defense the statements, and the court agreed, and there was a conviction. However, too bad for you. Supreme Court of Canada. And the arguments in favor of disclosure, so since 1991, seminal notion, and there are cases prior to that, this is sort of the watershed case, that this little guy here, through the defense attorney, has to make full answer in defense, and they have to have an opportunity to put forth any defense available, because don't forget, worst case scenario, right? Your orange is the new black. You're in the who's count. That's bad, right? That goes your personal freedom. That's the worst. So in order to guard and safeguard that, oh yeah, and by the way, this guy's innocent, we presume that, until otherwise, that they have to have every opportunity to have a full answer in defense, and the way to do that is to have disclosure, so you have all the evidence. Inculpatory and exculpatory, right? Anything less than complete disclosure by the Crown falls short of decency and fair play. We're all about decency on this side of the balancing. And so what happens? Lo and behold, the model code incorporates that, right? You've got the reference 5.1-3, commentary 1. The prosecutor has a special job acting for the public administration of justice within the limits of the law. Okay. And at page 511, we did that, right? No, you did that, right? Okay, excellent. Capital. Page 539. Let's move on. So the text was at page 539. What did I want to draw? Okay, so I'll just not highlight it, so I'll have to guess what I want. It is true that the defense has full disclosure of the witness's evidence and recall them to testify at trial. This would advantage the defense. Top of 539. The defense cannot cross-examine its own witnesses, and by calling evidence, it forfeits the right to address the jury last. These technical advantages are the natural incident of trial process, but should not be forced upon the defendant. So this case actually talks about, or this excerpt talks about, forcing the defense to call witnesses that the Crown hasn't called. The Crown is not obligated to call those witnesses. However, it disadvantages the defense. Okay. So we have the seminal case of Stinchcombe. This is the obligation. And this obligation of full disclosure has also trickled down into administrative law, right? Where you have a prosecutor that prosecutes, whether it's alcohol and gaming, licensing, any administrative law area will have the same obligation of full disclosure by the prosecutor, including the OSC, right, which is a administrative law tribunal, and the OSC in 2008 adopts the Stinchcombe concept in a case called Rebio Bail, and includes some other sort of guidance and language, picking up on the Crown's obligation to say you have to disclose all relevant information, whether inculpatory or exculpatory, right? In fairness, you have to err on the side of inclusion, and you have to separate the wheat from the chaff, because you want to offer the defense full answer, the accused full answer in defense. And the only way to do so is to have access to everything, inculpatory and especially exculpatory, right? And separating the wheat from the chaff is this notion of, this could constitute hundreds of thousands of pages of documents or evidence or all kinds of things. Some notion of separating out the relevant stuff, organizing it a little bit. You can't just dump a person with 2,000 gigabytes or whatever of information. It has to be sort of accessible in order to be available for full answering. Good question? Okay. So this is not in your textbook, so this is FYI. This Stinchcombe is in your textbook, right? Page 539, I gave you the reference. But this is an example of a Crown disclosure issue in 2017. So very basic concepts. They all make sense, right? They all make sense when you consider the imbalance of access to power, not power, but access to information and evidence. They all make sense. 2017, we're still arguing that. We're still talking about it, right? In this case, Ontario Superior Court considers the Stinchcombe notion of a guy who's charged with first-degree murder of a 70-year-old grandmother. This is the kind of work that Crown and defense do, right? And so what happens is, that the defense says, I want to take all this evidence and I want to use it for more than just my defense. And the case at the bottom, well in here, engage in the discussion, the extent to which defense counsel should be released from an undertaking not to disclose where an accused raises the question of disseminating the Crown's disclosure outside the court process for the purpose of making full answer defense. So basically, so when disclosure is made, right, then there's a deemed undertaking that says you can only use this for your defense, not for other stuff, unless you have permission of the court. And in this case, the defense was trying to say, well, let me use it otherwise. And the court says, well, Stinchcomb doesn't specifically say, third bullet, doesn't address whether it's appropriate for the Crown to impose terms, this undertaking. But in the end, the court was satisfied, having reviewed the jurisprudence across the country, that time has come to recognize whether or not the Crown disclosure provided to defense or self-rep. Same deal. I mean, sometimes it's a self-rep. Very, very tricky and dodgy, which is why we have things like duty counsel, because the consequences are so serious. And criminal procedure, unlike civil procedure, they have their own rules of procedure. Very complicated. So a self-rep is a subject of a written undertaking that a deemed undertaking nonetheless would apply, such as the only basis upon which the Crown disclosure may be used would be in the context of providing full answer defense to the criminal proceedings. Court decides you get full disclosure, but then you're limited. You're limited to using it to defend this case. You can't take it for civil matters, media matters, what have you. That's the point of this case. But the reason I include it is because, no? It's a hand because it's 2017, like 2 years ago, right? And we're still talking about notions of Stinchcomb and notions of disclosure and obligations and so forth. So, still. Okay. So the Crown has all these duties and obligations, but it also has some limits as to what it can and cannot do. You can't express personal opinions. You can't make prejudicial or inflammatory comments. You can't lead evidence that you know or ought to know, so someone will decide whether you ought to have known it, is false. So some limitations. You haven't got free rein. Does the defense have a reciprocal obligation of disclosure?
No.
It says right there. Why not? Why not?
Because I think for the defense because there's an uneven playground, so it's only fair for the Crown to disclose, but for the defense to keep his case not known to the Crown.
Yeah. It's an uneven playing ground, right? The defense is so disadvantaged, other than presumption of innocence, right? And defense counsel. There are 3 exceptions. Okay, and these are more for the fluid flow of the process and not surprise. It's never like on television. Never like on television. You're never going to see someone sitting in a box sweating with the cross-examination and say, I have a last-minute witness. My alibi is here. You wasted all your time coming this far. No, it's for the smooth flow of the process. So an alibi, it has to be disclosed. These are exceptions, right? We have all these rules and we have all these exceptions. An alibi has to be disclosed so the defense so the Crown can investigate. Double check it, do the due diligence, verify, and if there is a valid alibi, guess what? They won't even bring the case. Clearly, and it's valid, right? So they need time to check that. An alibi. A psychiatric defense, again, this is not a surprise thing, you have to do that in advance. And any expert opinion evidence is disclosed 3 days before trial because the Crown might have an expert, but this defendant has some money, hires an expert, and the Crown wants to know that. Because the Crown can go back and reevaluate the case, because if they don't know, and they spent 6 months bringing this case to trial, it's not a good use of resources. So these are sort of philosophical reasons why there are exceptions. Okay. So Krieger is one of those very helpful cases that brings us forward in the jurisprudence. And Krieger is at page 515, 515 of your text. Okay, Krieger, and the issue is blood tests, right? We know that. The Crown can get these. Where's our blood tests? DNA, blood tests, what have you. We know the Crown can get them. But in this case, the Crown did not disclose these, and they're favorable, right? Exculpatory, we know we have to disclose that. To make full answer defense, appeal to the Supreme Court, discussion of prosecutorial discretion. So remember, the Crown has, the police can say, yeah, charge, you got all this stuff. The Crown says, I'm not going to charge this, I don't have enough evidence. The Crown has that option. But prosecutorial discretion to bring the charge, arises out of decision to prosecute and related decisions, plea to a lesser charge and so forth, and doesn't cover the kind of stuff that the Law Society can cover. So Crown attorneys, just like all of us, you can do your work here, and the Law Society still has the ability to pursue for the same conduct, right? And why? Pages 16 and 17. See? So pages 16 and 17 discuss prosecutorial discretion, one aspect of which is, do I have a reader yet? Is at page 516. Prosecutorial discretion is a term of art. I'm like right in the middle there. Is a term of art. Does not simply refer to any discretionary decision made by a Crown prosecutor. Prosecutorial discretion refers to the use of those powers that constitute the core of the Attorney General's office, which are protected from the influence of improper political and other vitiating factors by the principle of independence. Crown's prosecutorial discretion has to do with evidence, charges, reasonable ability to succeed, and not political influence. Okay, and so one of those aspects of discretion is how do you build the case? I'm going to call this police officer. I'm going to call this expert. I don't need the DNA person because I've got the expert. I don't need the investigator because I've got a report or something. So you can make those kinds of decisions. In one case, in R.V. Cook, the Crown didn't call the victim, just the girlfriend's witness. So that's a strategic decision. Do I have to call the actual witness, the victim, pardon me, to say, yeah, this is the person that beat me up. Another example of the Crown's role, an overzealous Crown. In this case, R.V. Boucher, the Crown can, the ratio is, the Crown can review the evidence but must not use inflammatory or vindictive language. And remember R.V. Felderhoff? Unfair and demeaning comments by that prosecutor, right? OSC, Administrative Tribunal, by that prosecutor. John Felderhoff? Yes? Yeah, died. He died. It's a story in the paper today. Okay. John Palmer. Okay. And so the Crown is involved with the charging in these provinces. Sometimes the police makes the charge, lays the charge. The Crown still has the decision whether or not to prosecute, right? Because they have that discretion. And you can make a decision. Look, what if it's, for example, you have a case with an elderly person, was grabbed from behind, didn't see the assailant. Is that the kind of a case you want to bring forward? Reasonable probability of success. You have to make that call, and you're looking for a likelihood of conviction, but you may not be satisfied the evidence is enough to proceed. So, defense counsel, you don't have to make disclosure. You don't have, except for those three exceptions, right? Alibi, psychiatric defense, and yes. Except for but those don't happen every day in general. Right. But you don't get a free ride. Defense counsel can seek an acquittal by fair and honorable means, same obligations, ethical, and so on, without illegality, treat the court with candor, fairness, respect. The dominant duty is to fearlessly raise every issue, advance every argument, ask every question which will help the client's case, obtain for the client the benefit of every remedy, defense that is authorized by law, found in 5.1-1. What do those words, language, what do those words remind us of? Fearlessly raise every issue, advance every argument, ask every question. What does that kind of remind us of? Right. What philosophical approach does it also bring up? And who is our author of Zealous Advocates? Royal would be our current one, but who's our historical one from 1492 or whatever? Lord Brown. Remember Lord Brown? You are the only thing in the world, and everyone else falls away, and I see no one else but you, and I will be fearless, I don't care at all costs, and so forth. So you have that notion, you have those echoes of that philosophical approach right here. And it's down in 5.1-1, so you can find that in the model code. But you have to act resolutely, honorably within the limits of the law and with respect. So, you also have other limitations. You also can run maverick. As defense counsel, you can't assist the client to do anything dishonest or dishonorable. You can't help this person. You can't assist in a fraud, a crime, illegal conduct. You can interview Crown witnesses, tell them who you are, and you must never waive your client's rights without informed consent. So there's some restrictions, right? There's some reasonable extent to which the defense still has to act within their own boundaries, right? You cannot give bail to a client if the client insists. Yeah, worst case, the client wants you to do something, and we know this from other areas of law as well. Worst case is you may have to withdraw. And duty of confidentiality. Nothing new, we know this. This applies to all of us. Doesn't matter of your area of law, but certainly in criminal law, it's relevant for sure as well. So, you have confidentiality, but at the same time, you can't disclose that. At the same time, you have to use defenses that are not false or fraudulent, and you can't mislead the court. You're trying to, you've got this balance, right? You're trying to do the best for your client, and you're trying to be a zealous advocate, and you're trying to advance every possible legal defense, because you've got disclosure now, you can build up your defenses if you choose to do so. But you can't call evidence that you believe to be false. You can't suggest someone else did it, especially if you've asked your client, you've shown, you know what, I'm going to ask. I want to know this time. You've asked your client, they tell you, yeah, the guy was driving me nuts. I did it. So once you have that knowledge, you can't put forth a defense that says, oh, no, it wasn't him. It was his twin brother. On. June.
As far as I know, the second part, can't suggest someone else did it. As far as I know, that's used quite frequently.
It is quite frequent. Oftentimes, that's your basic defense. Or you challenge the Crown, you say, you didn't interview the next door neighbor, did you? And we know that the next door neighbor has a criminal record, and so reasonable doubt, exactly, right? So you can do that. However, if you have asked your client, in your wisdom, you think, I gotta know this time, and you've asked and they've told you, that would be false evidence, right? Because if you know your client admits that he or she did it, then it's not available to you to suggest that someone else did it. Because then you are making a false statement.
So only in those respects is what you're talking about, because this is used so often, like...
It is, as long as it's a viable defense, or your client says, no, I didn't do it for sure, then you can bring that forward. But with knowledge...
Okay, the knowledge
you
part.
can't, exactly.
Okay.
You see that?
Yeah, right.
That's-
Yeah, so I'm confused. So what if the client candidate committed murder?
Yeah.
Now you can't defend him? Or how are you supposed to defend him?
How are you supposed to you're next. How are you supposed to defend someone if your client said, yep, I did it? What's one way to do it?
I actually asked the defense lawyer the same question, and he said that if someone walked into my office and told me that they committed murder, I would tell them I can't represent them, but I would tell them to go to the next lawyer and then tell them not to tell them that. so that it's not, like, they haven't said it out of their mouth, and they can prepare a case for that.
So you have so there's an interesting real life example, right? Where you can't put forth a defense because you have knowledge of an admission of guilt, right? But you've given this person advice, they go to the next lawyer, and guess what? That advice, confidential, right? Cluttered by confidentiality. So no one can make you disclose that because you've got that client-lawyer relationship, right? Okay.
But
So
on
that's
the
one-
other hand, saying don't tell, isn't that in itself a breach?
Well,
Don't tell the lawyer.
Well, but you're not in court. You're not making that representation to a third party. You're having a personal conversation with your client, all of which is covered with confidentiality. You'd be in a different situation if you went to court. Okay, just a minute. Who else? Okay,
I just want to know one thing. I mean,
Relnack, and then, yeah.
there's privileged communication between a lawyer and a client, right? So the lawyer, even if they know that the client committed murder, can basically state that they never knew the client. It can never be proved that they knew about the murder. So how does that, like, I mean, affect the law? How does the lawyer become in any way, like, in any way culpable to the crime?
So no one can make that lawyer reveal that confidentiality, right? Right, because it's protected.
Yeah.
Okay. And it might be privileged, that's like a related issue. That lawyer has to be able to go home and sleep at night knowing
So it's only moral, right? Not evil.
confidentiality wins. It wins.
That's what.
Yeah,
Okay, for a theoretical scenario that when if your
Louder.
for the theoretical scenario that if you believe that your client is trying to cover up some else, and you even your client tell you that he did it, but you doubt about it, can you put forward a theory that alternative theory that you don't think your client did it and you.
I don't know. It goes back to this question: what can you do? So there's one example of a defense counsel that said what they do. They said, I can't defend this guy. I can't defend, but I can protect his rights because he's my client for this 15-minute conversation and send him off to a new lawyer, right? I mean, you have to make that decision. You have to make the decision. So what else, to answer the other question, what else can be done? You can say, I can't do it, off you go, right? What else can you do? You can challenge the police report. You can challenge the police witnesses. You can cross-examine. You can take all the steps that are available to you without saying, my guy didn't do it, because that would be contrary to your ethical obligations. But what you can do is, you can say, the police report was faulty because it missed the color of the light when the car went through. So you can do all of that because it's the Crown's job to put this evidence forward. And if the evidence isn't complete and there are holes in it, they can't convict, and you never have to say, my guy didn't do it, it was the twin brother. Look it, you gotta wrestle with this stuff, and you have to go to sleep at night, and you think, I'm gonna defend this guy, I'm not so sure, he's a little bit shady, whatever, so I can attack this is my job. Someone said, how can you defend someone that's guilty? It's my job. But you have to go home and have dinner with your partner and kiss your children goodnight and feel okay about yourself. So that's on you. That's on you.
I just have a question. Going back to the Bernardo case, where the lawyer had the tapes and didn't reveal them, how did that fit into what we're talking about now?
Okay, who thinks, what's going on with Ken Murray? How does that fit in? Yeah.
I mean, I think from what I remember, he didn't have the intention to cover anything up, but if he did, then that would definitely be him breaching his, fact that he's a misleading offense or he's covering information. That would become an ethical issue.
So in his own criminal proceeding, that's where was missing, right? So he didn't have intent. I think also factually, somebody correct me, I think factually, he didn't actually view the tapes.
Yeah.
He did.
He did, right. So he knew they existed, but he didn't have actual knowledge. Whether he had, implicit knowledge, or suspicions, like your example, I don't know, he made those calls, and what happened, he got prosecuted criminally, he was acquitted, but still, he had to go through all of that, right? Plus, if you know the facts of the case, like, how do you sleep at night? Like, how do you sleep at night? Okay, so, murky, good stuff, right? You have to stop and think and work through these issues. One.
Well, in my country, sometimes criminal lawyers receive payments of criminals by stolen stuff. So they stole watches and paid the lawyer with the watches or money, or well, it's also money laundering involved. And how, as a lawyer, can I protect myself to not to get paid with that kind of money or things that had a legal origin?
Okay, hands up. Your client comes and says, I want you to defend me and I want you to, in Canada, right? In Canada.
Yeah, Canada, yes.
And I want you to hire the expert and I want you to defend me and I'm a nice, good, clean guy. Here's my gold Rolex and here are the keys to my BMW. Go. Hands up. What do you do with that? What do you do with that? Kasim?
Sell the BMW, take the Rolex.
Priorities, right? No maintenance. It's okay. It's one option. Anyone else? What else? What do you do with
I
that?
don't think you're legally, ethically can do that.
Well,
isn't there something
let's
in the
say
rules?
you suspect it's proceeds of crime. It's not his own real, actual $60,000 Rolex, which I agree, right? Way less work.
But even if it was his,
Even if it was his,
sure,
yeah.
I think that you couldn't do that.
Okay, okay. How you get paid? How you get paid? I mean, I don't think there are any rules about how you get paid.
Oh, okay. I
mean,
thought
the guy
there was
could
some
sell
rules.
his Rolex and give you the money, right? But,
Yeah.
But I think Juan's example is you highly suspect this fell off a truck. These are proceeds of crime. That the watch is stolen and he owns it now. He's giving you proceeds of crime. So I think that's the problem, right? So A, keep it. Other options. What else can you do with that kind of a client?
There are also
I need your name, can I start?
Mohammed. There are limits on the lawyers by the system, so that's why the system always mentioned that if you have to take the fee more than I think $7,000, you need to report.
Yeah.
So
cash 7,500. Yeah, someone check me on that. Yeah, so suitcase of cash, here you go, right? But what about this business of the $50,000 Rolex? What can you do? You can do what the defense counsel said. Sorry, dude, I cannot help you. You have to turn work away. So 2 issues with turning work away. Like, this is work. Like, this, like, you know, right? Because these guys aren't paid by the government. They're paid by the clients. This is a government employee over here. You turn away work, and maybe, I don't know, that person, if they are innocent, doesn't have proper legal representation. Let's say you're the best lawyer and they want you. May not have proper defense, right? So murky issues for sure, difficult decisions to make. Like there's no clear answer, right? You got to do what you're doing now. Think about it, talk about it, ask your friends, ask your mother.
But for example, a drug dealer, and you know that the origin of the money is from drugs, and you can be charged from money laundering, but in your case, this criminal never can hire a lawyer because he is going to always pay you that kind of money. So what's the solution?
I mean, you have to live with yourself. It has to be your decision. You can't make a decision for your next door neighbor lawyer or the lawyer in the other town. You have to make your own decision. If it feels to you that there's something wrong here, maybe that's the call that you make.
That's basically answers the question. You're basically giving your services. You're not doing money laundering, right? Irrespective of
Maybe the criminal justice system says maybe by taking his money or his pawned watch and putting it through your trust account, maybe someone's going to say, oh, you are kind of.
So what if you're giving your services when you're a lawyer? You got to represent.
Yeah.
You're the last lawyer.
Yeah, exactly. Yeah. So what do you do then? Do you say, I'll do it pro bono? Because you'll never buy that Rolex if you're working pro bono or the BMW. Okay, take a break. Thank you very much. Take a break. Page 504, when you know, in quotes, that your client is guilty, commentary 10 of the model code, 5.1-1, we had it up there somewhere, makes it clear you're not obligated to plead your client guilty, but you can properly take objection to the jurisdiction of the court, the form of the indictment, admissibility, or sufficiency of evidence. So what you can do is, attack all these things, right? You can attack all these attributes. You don't have to plead guilty, obviously. But you can't put forth a positive defense. Okay. So the challenge to the Crown's case. So we know you can challenge the Crown's case. You can challenge all these things. You can poke holes. Poke a hole here, poke a hole here, poke a hole. Poke holes in the Crown's case because the onus is on them. You don't have to prove your person innocent, right? Because they're presumed innocent. They're presumed innocent the day the trial starts. You're already there. But there's a difference between challenging the Crown's case and putting forth an affirmative or alternative account on behalf of the accused. If you've gone ahead and asked, and you know your client is guilty, you cannot make that affirmative, proactive defense because you're misleading the court, because you know otherwise, and you're an ethical person. So if you believe your client is innocent, you can go further than if you believe or know, have actual knowledge. You can cross-examine the Crown witnesses, you can test credibility, you can object to admission of evidence, you can do all kind of procedural stuff. You can poke holes in this all day long. So, defense counsel, limitations. It's not a free-for-all. You haven't got a blank slate to do whatever the heck you want. You can challenge the jurisdiction. You can attack the indictment. You can say, no, didn't meet the onus, didn't discharge the duty to prove the case, sit down and do nothing. What you cannot do is suggest someone else did the crime. You cannot call evidence believed to be false, and you can't allege an alibi unless it's accurate, unless it's true, and you're satisfied that it's true.
Question. That's
Anyways.
sorry.
Go ahead.
It means that later is suggested because you are supposed to agree.
Right, but are you talking about the alibi?
Yeah.
Okay, but an alibi is a specific defense, right? It says, I was in Las Vegas the day the guy died. Here's my hotel receipt. Here's my birth. Right, so that's a concrete defense to say I couldn't have done it, I wasn't there. That's an alibi. Okay, but that's different than raising reasonable doubt. Reasonable doubt is this witness is not reliable, so you should doubt whether or not the Crown has proven their case. This lab report was tainted because they lost a vial of blood. You should not believe that report. So you're raising doubt for the jury. But you're raising doubt. You're poking holes in the case to say there's doubt here, and if you're not beyond a reasonable doubt, you can't convict, right? Versus you can't raise an alibi if you know it's not true, if he really wasn't in Las Vegas. Oh, what did I just do? Did I go like 6 slides forward? Oh man. It's because I talk like this.
You can just go one.
Wow. I really went. Seriously? No, I'm going forward. Oh, thanks. All right. You can't, right? Where were we?
27.
Huh?
Slide 27.
27?
28.
There you go. There you go. Okay. All right. Okay, so here's a nice pictorial. Based on the case law, what the Crown obligation, be fair, objective, dispassionate, do your job, but argue forcefully for a conviction because you think there's a reasonable likelihood of success. The defense vigorously represent the interests of the accused, but be mindful of overriding rules to the court, such as don't put forth an alibi witness or evidence if it's not valid. So here are some of the cases that speak to the Crown's duty. Okay. So did we reference? Yeah, we did. We referenced. Sorry. Just going to go back. So for the purposes of extensive challenge of the Crown's case, we have Model Code 5.1-1. I think we saw it. It's not up there right now. 5.1-1. It's got a series of commentaries behind it, so make a note to read those, including 5.1-1. When acting as an advocate, must represent the client resolutely, honorably, limits of the law, right? And the commentaries include things that we said, you can't have a personal opinion, but also look at commentary number 8, 5.1-1, all the commentaries. This is an advocate in court, which includes the Crown Counsel, right? 8, thou shalt not bring frivolous or vexatious objections. It's on the civil side. And then in commentary 10, admissions made by the accused to a lawyer accused may impose restrictions on the conduct of the defense. The accused should not be made aware of this, for example, and the accused should be made aware of this. For example, if the accused clearly admits that the factual and mental admissions are true and voluntary. Yep, I did it. Mens rea, actus rea, all good. I did it. Then, and if the lawyer is convinced the admissions are true and voluntary, may properly take objection to the jurisdiction, the form of the indictment, admissibility or sufficiency of evidence. But you cannot suggest someone else did it if you believe that the admissions are true. You can test the evidence, but you cannot put forth an affirmative alternative defense if you know that is not the case. 5.1-1. Okay. Commentary 10. The commentary is good stuff because it puts meat on the bones. So, R.V. Levert, or Levert, is at page 541. And these are some limits on the Crown. And in this particular case, the Crown cross-examines. You can't go too far. The Crown has limitations. You can't go too far. In this case, the Crown's cross-examination says, you pick the perfect victim. And the court cautions the Crown not to comment on its own role, may cause the jury to give more weight to the Crown's submission. So in this case, what happened was, the Crown says, ladies and gentlemen of the jury, I'm a Crown prosecutor. I have all these ethical obligations. I have the onus. I have the burden. I have the public as my client. I have all these high standards. Oh, and the defense doesn't have any of that. True. But the court says you can't make that comment because the jury might think, Crown's got all these high ethical duties. The defense doesn't. I should believe the Crown's case. So that was deemed to be inappropriate. The Crown says you cannot do that because it may cause the jury to give more weight to the Crown's submissions. And you cannot criticize defense counsel. That goes to civility and proper conduct of the hearing. Okay, so that was page, I gave it to you, right? 541. R.V. Hillis, 536. 536. We know this, right? This is a 2016 case. Can the Crown withhold reliable witness evidence that assists the accused? No, because it's inconsistent with the role as custodian of the public interest. The defense gets full disclosure, but they can't call the witness. Because what are the rules, right? If the Crown calls a witness, the defense gets to cross-examine, right? If the defense calls a witness, the Crown gets to cross-examine. Why is cross-examination so important? Litigators, any litigators? Why is cross-examination so important? You have, exactly, you can poke holes and check the stories. You have way more latitude in cross-examination. You can say stuff on cross-examination that in chief you're going to be cut down at the knees that you can't do cross-examination in chief or direct examination. So cross-examination is very powerful. So this case says that by not calling a certain witness, forcing the defense to call, the powerful cross-examination opportunity lies with the Crown, and that was so the Crown was directed to call the witness, was told, you call the witness, and that gives cross-examination advantage to the defense, Jim.
But also, you're not just, I think, cross-examining, but you're also building your case, which when the Crown had the witness, you're not getting that kind of feedback. So with cross, you also get an opportunity to build your own case.
Yeah, absolutely, absolutely. That's your opportunity to take that witness's evidence and put it in a more favorable light. Yeah, exactly. That's exactly right. That's exactly right. Okay, that's Hillis. And Anderson. Okay, good. So R.V. Anderson, this case goes to the Supreme Court of Canada. And this is a case that talked about prosecutorial discretion. Remember we said the prosecutor, the Crown Attorney, has discretion as to who to call, what to charge, how to frame the charge, how to bring the case forward. But this case, and I'll give you the page references for Anderson. Anderson, pages 511 to 528 are the parameters. And it deals with the issue of prosecutorial discretion. In that case, and the court, the Supreme Court, says we're going to give you lots of deference. We're going to defer to you, Crown Counsel. The court allows considerable deference as to how the Crown is going to frame the case, who to call, and so forth. The onus on the claimant to show an abusive process on the balance of probability. So where the court says, Crown, you've got leeway. You can choose how to bring your case, if you choose to bring it. The defense can say, I'm going to challenge that for abusive process. But if, meaning you've chosen to charge me, you've abused your considerable powers with the government standing behind you and so forth, there's an abusive process of fairness. But if the defense makes that claim, in R.V. Anderson, we know the court says, well, you have to prove that. That's not just the defense. I stand up and I say abusive process, the police were biased when they charged me. You actually have to prove it, and also on a balance of probabilities. So your standard is actually lower, right? Because over here the standard is beyond a reason. This will be the simple standard. That's what Anderson tells us, right? Because the court says, we presume good faith on the part of the Crown, so now we're going to make you prove your allegation of abusive process. Presumption of good faith. The court controls its own process and will penalize abusive process, abusive cross-examination, etc. But there is deference to the Crown as to how they bring the case. That's within their bailiwick. Conduct of the defense. 2014 in this case. Jenkins. Page 492 is this case, 492. Yeah. Where's Jenkins? Somebody, oh, here it is. Sorry, 494. Sorry, 494 is the reference. And so what happens in Jenkins in this case is Powell is defense for an accused person. So Powell finds himself in a pickle. Powell is the defense counsel for an accused. Powell hires Peel. So they're in the middle of trial. They're like, it's a 2-week trial. They're in the middle of it, 1 week down. And Powell stands up and says to the judge, I've hired counsel to represent me. And wants to be allowed to withdraw. So he wants to withdraw. It's the middle of trial. So normally we know you can't withdraw if it's too close to the trial date because of prejudice to the defense, getting someone new and so forth. This is in the middle of trial. And the court says yes. Why? The information that the accused conveyed to Powell, so the first lawyer, was fundamentally inconsistent with the essence of the case advanced by Powell, the jury, to that point. Any active participation by Powell would be problematic, even silence. So what happened here? What happened behind the scenes? What happened?
Maybe disclose information.
So you're going along, I don't know, I didn't ask, I believe he's innocent, I'm fighting the good fight. A week goes in, the evidence is going in, the Crown's putting in their case, you're cross-examining witnesses, you take a break, you're preparing at your office that night, the guy says, you know what, actually, good job, Crown, I actually did it. So now, Powell is in a situation where now he has information, and this information is found to be fundamentally inconsistent with the essence of the case advanced so far. You can read between the lines, right? What happened. And Powell's smart. He's not going to stand up and say, I withdraw. No, he hires someone to represent him, to argue the case. And he's allowed to withdraw. So that's a situation where before, like, maybe before you start your case, you satisfy yourself, or you ask or you don't ask, and you figure out your defenses or what have you. This is in the middle. This is halfway through. All of a sudden, you've got a migraine, like a migraine. You'll find this out, right?
So does this suggest that you should maybe lean towards asking, finding out?
So of course we don't know, because they'll never, it's confidential as to how he found out or what he found out. It might have been blurted out, he might have found evidence, we don't know. We don't know. But remember, if you do decide to ask and you have actual knowledge, all of a sudden you shut off certain avenues of defense. So give me a page reference for that one. That was 492, yeah, through 496. So I'm sorry? Jenkins, 494. Okay. Johnson, let's see, 488 words. 488 for Johnson, yes. Yeah, so 488 for Johnson. So this is another example. This is a 2014 case. The accused enters a guilty plea, but later says, I was pressured by my lawyer to do that. For defense to assist a client to enter a plea for crime he did not commit is a fraud upon the court. Like, you're too busy. You've got too many other trials. Too bad for you. You cannot pressure a client. That's what this case tells us, if you needed to be told that. The defense counsel cannot help a client even if a client insists that he wants to plead guilty. The defense counsel must remove himself from everything. Cannot assist with that because, again, it's a falsehood. It's a fraud upon the court to stand up and say that because your client wants to plead guilty. Who knows why? Maybe they're protecting someone. Who knows, right? Okay. Page reference. Got it. Physical evidence. So physical evidence, right? So we're talking about guy runs into your office, hands you a bag, and inside the bag is a bloody shirt and a bloody knife, and it says, put this in your safe and don't tell anybody about it. So, or it tells you where the body is, or he tells you where the body is buried. So our model code says you cannot knowingly deceive a court by offering false evidence, misstating the facts or law, or suppressing what ought to be disclosed. Question, did Ken Murray get himself into a similar mess? You also cannot counsel or participate in concealment, destruction, or alteration of incriminating evidence, or otherwise obstruct justice. Ken Murray rings a bell, and the criminal code, because you can be charged for obstruction of justice if you are helping to harbor and put the bloody knife into the safe. Oh, look at that. Look at that. R.B. Murray. It's like I planned it, right? So R.B. Murray, police search his premises, didn't find the videotapes. He keeps them confidential, 18 months, 17 months. Eventually a new counsel gets involved and turns the tapes over to the Crown. You know, question, should this have been done? Whatever. At the start, he's charged with obstruction of justice. We know the outcome of that case. So Law Society has given us guidance. This is FYI, not part of your materials. But they do give you some guidance about physical evidence. In particular, notice, bullet point 3, communications about the physical evidence is confidential. The evidence itself is not. So when Ken Murray doesn't hand over the videotapes, the next lawyer that comes up to defend when he gets off the record does hand over the videotapes, but not the confidential conversation of Bernardo saying they're in the roof raft, you know, wherever they were. So that's an important point, is the distinction between the communication. And the second, the last bullet, if you become aware of the existence of incriminating physical evidence or decline to take possession of it, you cannot participate in its concealment, destruction, or alteration. And that goes on. You can read that for yourself. Criminal court offenses, you can be charged, right, with obstruction of justice, hiding, disposing of evidence, accessory. But we have the mens rea, like, so that's the component that Ken Murray, his trial wasn't satisfied. And a Price lawyer accepts the smoking gun or the blank shirt. A confession, you know, crying, blowing your nose, you hear a confession, and if the client confesses before trial, you don't have to withdraw, but you can if you think that your client will be prejudiced. It'll restrict the types of defenses and challenges of the witnesses, but not allow the client to perjure himself. So if you've got this confession, you know it's the case, you're limited, right, in your defenses, and you can't put your client in and say, I didn't do it, I was in Las Vegas. You can't do that. It's a fraud upon the court. But you still owe your client a duty of confidentiality, so you can't disclose that he told you. Makes sense, right? So perjury. So perjury is the opposite side of the coin, is you know your client is going to get up and so you must have actual knowledge, first of all. You can't be unsure. You have to be certain that the client is committing perjury, not just a belief, but actual knowledge. And you have to be careful about assuming it. And if you have any doubt, you shouldn't allow your client to testify. Fraud upon the court, same time. Plea bargaining. So one of the things that the Crown can do, for sure, in their discretion, is say, I'm going to charge, whatever, first-degree murder. And the defense says, well, yeah, but there are mitigating circumstances. Can you bring it down to, I don't know, manslaughter or second-degree, whatever, plea bargain it down to lesser sentence, lesser charge. And the Crown can do that no problem. But plea bargains have to be approved by the court. Judge is not bound, so it's not done until it's blessed. And the deal can be repudiated, but it has to be on the basis of something, for example, a misrepresentation. Okay, and if there's a plea bargain, then the obligations are counsel must be present, the judge is not bound by it, the Crown should consult the victims, victim impact statements, and appeals of plea bargains are only in the rarest of cases. New evidence, misrepresentation, something very serious. And this case is not in your text, so it's an FYI.
Oh, I didn't find it.
I'm sorry?
Didn't find it.
You didn't find it? But Nixon is. Nixon is a Supreme Court of Canada case about a plea bargain. And it's at page 533. 533, yes, there it is. And what happens is the Crown repudiates. So what happens is the Crown enters into a plea bargain with the defense, but then repudiates, changes their mind. And the case is reviewed because of the deputy minister after the original plea. So basically the guy's boss, the Crown's boss, the deputy minister, determines that the strength of the case was flawed, didn't consider all the evidence, the plea of careless driving was contrary to the interests of justice, so the plea was too low. And here's what Nixon, the Supreme Court of Canada says in Nixon, so long as the proceedings are ongoing, so there hasn't been a determination or decision yet, so long as they're ongoing, the Crown may make a further decision whether to prosecution to continue for the nature of the charges. And it's only reviewable on judicial review if there was an abusive process, and there's no evidence of abusive process here. So this case is important because it's the Supreme Court of Canada, and because it shows that this is like it's like a process. It's ongoing. It's ongoing. And a plea can be basically how you resolve a thing without a hearing, right, without a trial. And a plea bargain can be entered into, but in this particular case, the Supreme Court says, yes, but you know what? We didn't get a decision. We didn't get a verdict of guilty or not guilty. We didn't get that final conclusion. The thing is still going. It's a work in progress. It's a process. It's ongoing. And during that ongoing process, you don't have to be steadfast, you Crown, in your approach to the case, you can change your mind, you can review the evidence, you can have sober second thought. Warning to defense counsel, it's not written in stone, right? If the proceedings are ongoing, the Crown may make further decision as to whether to continue or the nature of the charges, or say, you know what, I'm not going to honor that plea, and that's okay. I'm not going to honor the plea, you can change your mind. And that's the importance of R.B. Nixon, and the page is worth 533, right? Oh, this is an example where you have co-accused. We talked about this before, I think, in class. Co-accused, where one of the defenses is, no, he did it, no, he did it, no, he did it. So you have a conflict of interest in the criminal context. I think we probably looked at that in the conflict of interest section. But if you do have two clients, if you choose to do it, you have certain guidelines as to how to proceed with that. So we'll do corporate law now. That was criminal law. It took us a bit longer, but anyway, it's all good stuff and really thorny issues for sure. So corporate law. Corporations are separate legal entities, right? Your client is the corporation, not the individuals that run it, although you need a live person to give you instruction. Like, you need someone to speak of the corporation. Your duties are to the corporation, and the retainer should be clear about who the agents are, who we can take instructions from, right? And because it's a corporate client, there are employees that work for the corporation, you have to separate out the obligations of the corporation. If it's a public corporation, to its shareholders. And if you're in-house counsel, then you're an employee as well, so you've got that thorny situation. And so some professional codes require the counsel to a corporation to be far-reaching, to consider the broader impact of what this client, the corporation, wants to do. And they give examples of the customers or clients, assuming it's a retail, manufacturing, what have you kind of a thing. Or the environment, assuming it's something that uses out dirty water during the process or what have you. And to gain every advantage for your client may not necessarily be the right thing to do, such as your client's shares in their stock will rise if there's more manufacturing, but it causes a lot of effluent to go into the drinking water. So when you think about this corporate responsibility, what does that ring up? What does that notion, philosophical notion, harken us back to in terms of considering customers, the clients, the environment, and so forth? What philosophical approach does that remind us of? Broader picture. Consider wide perspectives and views. Lord Brown's adversary. Sustainable professionalism, right? Trevor Farrow talks about you can't just think about your client the way Lord Brown says, you have to think about the broader pictures and broader notions. And that's sort of kind of baked into this notion of keeping your corporate client in the context of what the broader environment is or context. Who's heard of Enron? Okay, so the Enron case was a collapse of an oil pipeline with a very complicated series of transactions, bankruptcy, and eventually, as a result of that case, what happened was the notion that so economist Milton Friedman, so one of the outcomes or one of the domino effects is a debate about this issue of corporate responsibility. And one individual argues it's the social responsibility of corporations to increase profits, right? That's the whole raison d'etre. That's why we exist as a corporation. Putting more people to work, paying more taxes, all public good. But business ethical people in business caution against a myopic pursuit towards earnings. So questions that limited view The quarterly reporting syndrome that pressures companies to meet earnings expectations, promotes temptations that can push some to distort the truth. And we're trying to find a just and ethical corporate culture to breed fair and lasting business principles. Unlike Enron, which went bankrupt, thousands of people lost their job and their life savings because part of their pay was in Enron shares. So that's the consequence. And this is an American company, so in 2002, the SOX, Sarbanes-Oxley Act, some legislation flows from that to enhance corporate responsibility, financial disclosures, combat fraud, and the Dodd-Frank Act was a subsequent act, also American, to enhance financial reform to reduce risk.
Has Canada or Ontario done any similar action?
Not that I know of, although there were some consequences because many Canadians worked for Enron as well. Yeah, not that I'm aware of. If someone knows otherwise, please let me know.
Wouldn't it be harder for like lawyers that are working for big corporations to act in a way where they're kind of caring about everything and thinking about like a sustainable profession? Because if your boss is telling you that you have to give them advice on something and you know that it's going to lead to like some sort of, say, an environmental deficit, but if you go against them, then you can get fired as an in-house counsel.
Right? Hands up. Who says you should do what your client asks you because not only is your client, is your employer as well? Okay. And who says I cannot live with myself if I know I'm polluting the drinking water? But that means you'll be fired out of the job.
So you leave your job.
Yeah.
You gotta walk away.
You gotta walk away. So the answer is, it depends, right? It depends. Do you feel like serving your client's interests is your job, and it's your only client, and it's your employer, and you can live with yourself? Maybe you do. And if you say, I just can't live like this, I'm gonna quit and find a new job, and I'll have to move on. Is it difficult? Sure it's difficult. Sure it's difficult. How do you resolve it? I don't know. You resolve it by thinking through all of the questions that you're asking yourself, and speak to your senior partner, and speak to your colleagues and your friends to resolve that. That is for corporate lawyers, that is almost very often an ethical issue that they struggle with, because there's no clear answer. What do you do, right? We'll see next day government lawyers who are asked to get a result and how they have to deal with it, and something called the torture memos. So we'll talk about that next day. Similar kind of concept, doing what your client wants. It's not a corporation, it's the government. Okay, post-Enron, is this, where are we post-Enron? Okay, references, model code 3.2-H, you can read that, about the Enron corporate client issues. Post-Enron, this is FYI only, SEC requirements for lawyers, what they can and cannot do. And in the Ontario context, Wilder versus OSC, page 575 is the reference for that. And that is a case where the lawyer, thank you very much, the lawyer is acting for YBM, which is a corporation, right, in front of the Ontario Securities Commission, accused of violating provisions respecting material misrepresentations. You can't make misrepresentations to the regulator when you file your annual documents. And the the court finds, this is the court, right? The court finds that, so the misrepresentations by the lawyer to the OSC on behalf of the corporation as a corporate lawyer were found to be misleading, and the lawyer says, well, you can't prosecute me, OSC. I'm just a lawyer for the corporation. The Law Society, maybe the Law Society can because I'm under their jurisdiction. No, the court says, no, too bad for you. Both the Law Society and the OSC have public interest concerns, although they're different, but both can prosecute the lawyer. So the lawyer is acting in his capacity as counsel for the corporation for the OSC, and he's going to get a finger wagging, and then the Law Society says, okay, when you're done there, then we're going to have a look at you as well. Should securities regulator have responsibility for regulating the lawyers? The lawyer filed misleading documents on behalf of his client because the corporation told him to. There was no basis to hold lawyers immune from the regulatory powers of the OSC for misleading filings. In-house counsel versus external lawyers, obligations are the same, whether you're hired by the corporation from a big fat giant law firm or you work in the corporation as one of its employees, same obligations. Yeah, so is your role simply to follow the instructions of the corporations? It's the age-old question, right? Duty to avoid dishonorable or questionable conduct. Be on guard against being the tool or dupe of your client. Remember the tool or dupe of your client notion, which is in our model code. It is found at 3.2-7. And for the next one is whistleblowing, which is blowing the whistle when your corporation is doing something you think is inappropriate. And this is a, so to give you so the reference to the in-house lawyer versus external, yeah, is 585 of your text. And then being the conscience of your corporate client, model code references. And this is an FYI of a case, R.E. Kasman, who was disbarred and sent to jail for 7 years for engaging in a small business loaning company. And so we have the tool or dupe reference in your model code, right, 3.2-7, and this case simply highlights that. Kasman did not profit from the deal outside of the fees he collected. The panel found that he prepared false affidavits. He was not a dupe, but instead averted to the probability that these transactions were fraudulent, avoiding making further inquiries because he did not be fixed with actual knowledge. It kind of goes back to that criminal law concept that,
what we were talking about earlier.
If you don't ask, you don't know, not good enough, right? Not good enough in this scenario. And again, this is not your text, but it goes to show you what year is this case. It's got to be post-17, right? Post-16. So you can't. So your defense is not, I wasn't sure, so I didn't ask, because now he's preparing false affidavits for fraud upon court. Oh, if he's still appealing, so it's got to be fairly recent, right? And last of all, the whistleblowing. We know what whistleblowing is, right? If you think the corporation is behaving in a way that is not acceptable, then you have obligations to, if you perceive illegality, it's on you, it's your ethical obligation. Too bad if you're the employee, I don't care if you lose your job. You have to take steps. If you perceive illegality, you have to inform employees of illegality, and then you have to report to the CEO, then to the board, and if nothing works, you may have to resign. That's called reporting up the ladder, you can imagine, right? Up the ladder is that's 3.2-8. 3.2-8, our model code, 3.2-8 reads, dishonesty, fraud, when client is an organization, right? So your corporate client is acting illegally, and it reads, employer who is employed or retained by an organization to act in a manner which the lawyer knows the organization has acted, is acting, intends to act dishonestly, fraudulently, criminally, illegally, must do the following, report up the ladder. You can read the commentaries. And sub-commentary number 5 reads, you have to report up the ladder. Ultimately, you may have to resign if no one does anything at the top of the ladder.
Sorry, just a really quick question. Is it normal to inform employees? How is that? In what context?
Okay,
is that?
so that point may not be clear. I think the point of whistleblowing is with confidentiality issues. You have to take certain steps to try to dissuade maybe the employees. I'm sorry if that's not clear. I don't think you send an reply all memo. I don't think you send a reply all email. No, that's not the case. That might be not clear. The point of whistleblowing is you have to raise the issue if you perceive it. You have to put it in writing, and you have to escalate it up the chain. So don't take that one.
I think it would be more towards like informing the managers, like the board of directors.
For sure, you have to do that.
There's like one of them that's doing something.
For sure, you have to do that. Right, and then if they ignore you, You've got to go up. And if they ignore you, yeah, at the very top, if the CEO says, get out of here, and you say, oh, I quit. Okay, I think that's it. Thank you very much. Thank you very much.